proceed to the next session, session 2, which will be on the governance framework, so the legal, ethical aspects. And that, I have to say, was one of the more complicated topics within ATHENA, within the ATHENA project to address. In fact, and that was is also one of the outcomes of the ATHENA project, is a development of the Belgian real-world data reuse framework. In fact, the framework aimed to answer the governance aspects for various applications of real-world data. Of course, to improve quality of care, we have been discussing it today extensively, scientific research, also for price and reimbursement, and then more specifically, outcomes-based reimbursement, and then of course also for economic ecosystem development and innovation in a broad sense. Now, the framework provides, in fact, a structure, or provided a structure, to discuss solutions on important aspects associated to governance. Aspects associated to the data process steps, starting from data collection up to data quality verification, to data analysis and also reporting, so the inner circle that you see here on the screen. But also the enabling foundation, with aspects like the broader governance, also about funding and incentives to collect qualitative data, but also to do the efforts for analyzing the data, and then obviously also data privacy and data security. In fact, the solutions for each of these elements of the wheel that you have seen have been discussed extensively in multi-stakeholder dialogue. So we had several round tables where solutions, potential solutions have been discussed, have been addressed, and we have also looked into other countries, what has been done there as potential starting points for solutions in Belgium. And we also have looked into, is this also feasible within the Belgian context and within our healthcare system? Based on that, the solutions have been developed on what has to be done, how it has to be done, and also who it has to do. So that means also in terms of roles and responsibilities. A report of these solutions have been published and have been presented also earlier, and can be downloaded, by the way, also from the Innovigate website. Then, beginning this year, the question came how to further implement this roadmap, or this framework, this our real-world data framework, governance framework. And that was the starting point of the real-world data for Belgium initiative. Again, a very broad multi-stakeholder initiative, which is open to all, and where today all stakeholders are represented. Obviously, also, again, with a governance board where all stakeholders are represented and chaired by Jo de Kok, and where also the government is involved right from the start, with the aim to also produce policy recommendations that can be later on, and that will be in January published, can then also later on be translated into policy. The initiative aims to address the key challenges, the key hurdles in implementing the governance framework. There are aspects that are linked to, for example, what we call the supporting layer, the playbook, the governance and legal aspects. Think about one consent form for Belgium, one GDPR or uniform GDPR interpretation for Belgium. So these type of aspects, but also for hospitals that want to start in real-world data with a kind of guide book, a playbook, a step plan on how to do this. Another working group is working on the development of a data quality framework. So how to collect good quality data. We had a discussion today. If you want to use real-world data to generate evidence, of course, good quality data is of primary importance. And then also the integration, standardization, and structuring of data has been started as a separate working group, but has also been combined with the Belgian Odyssey chapter to bring this along. Then the enabling foundation. That was also one of the challenges that we encountered in the ATHENA project. These are all very new things that have been discussed and on which solutions have been defined. So there's quite some work also to be done on education, awareness building, so that also broader stakeholder communities know what this is all about. And also, we need, in fact, not to reinvent the wheel. There are many health data initiatives within Belgium, but also internationally, from which we extracted best practices that could be sources of inspiration for solutions here. And then also the multi-stakeholder collaboration to bring all the necessary parties along in this project to collaborate, to work together, and jointly develop solutions. And then also the last working group is then different pilot cases, different examples are being used, in fact, to put these things in practice, to learn along the way, and also to be the sources of further generalization, further extending that to other disease areas. So to have more generic building blocks that can be used. So in fact, that's the ongoing. Like said, the real-world data for Belgium initiative will lead to a policy report in January, and from there we will continue with the working groups. Perhaps new working groups will be added to it, depending on where the challenges and needs are. So on this governance topic, and that was a key topic within ATHENA, we have two very interesting speakers that we have for today and for you. First of all, Griet Verhenneman. She is the legal expert on e-health. She is has an academic background and extensive experience, and especially in interdisciplinary research. She's data protection officer at UZ Leuven and is on her way to Ghent, University of Ghent. Of course, she will bring IT, IP, and also the whole topic of ethical and legal considerations into the mix. So please, Griet, you can come to the floor.
Thank you. It's an honor to address you today, to be here. Although I have to admit I'm not really entirely at ease today, given that in this morning's session we already heard that privacy was only for sissies. And this afternoon we heard that I was kind of a blocking factor for the ATHENA project. Thank you, thank you. Luckily I'm moving to Ghent now, so no. Being silly here, what I would like to do with you today is to take you along the journey that we have encountered with the ATHENA project, and giving you some remarks on how we try to integrate the difficult and complex legal framework that we are facing. Because to be perfectly honest with you, if in this project we already ran delays, it's not going to become easier. The legal framework is becoming only more complex. It's not becoming easier. Yes, we are finding our way how to deal with the GDPR, how to implement it, how to interpret it, how to find ways to bring it into practice. But Europe is not only regulating personal data today. Europe is going beyond. Europe has defined a fit for the digital age strategy, encompassing legal frameworks for data, for the digital market, for AI, for cybersecurity. And although maybe in our context we can skip the digital, we have to take into account all the three other parts. And as you can see, GDPR is just one of the very many building blocks that are there. So the bad news for today is, no, it's not going to become easier. The good news that I would like to bring you today is that yes, we have come away, and yes, this project has helped us to do some groundwork, I'd say. We definitely have some complex issues to continue to solve. But we are making progress, for sure. I think technical measures such as the federated learning frameworks can definitely help us to enhance privacy, can definitely help us to open up very closed medical records where confidentiality and privacy are topics that are very much appreciated and stressed by citizens, by some patient groups. Others tend to focus on what it can bring to them, but nevertheless, privacy is a big issue. And if we can circumvent that by using some technical measures, then that will definitely help us for the better future. We have also made progress, I believe, in discussions on data custodianship versus data ownership. Although I still regularly hear people talking about data ownership. It has been stressed increasingly in literature that there is no such a thing as ownership in Europe, at least today. So I will give some views on that. And the lawfulness of secondary use, as we have heard from Ingrid just before, as we have also seen slides from me earlier this morning on the groundwork that we did on the secondary use of real-world data and the framework that we developed with the 7 university hospitals there. I'm sure we have made some progress there as well. But before I do that, there is a bit of an elephant in the room. There is a bit of an elephant in the room, and the elephant is called anonymization. We, even after 20 years of research, do not seem to agree on the concept of anonymization. Anonymization is a concept that has been studied long before the GDPR. It was already relevant at the times of the Data Protection Directive and all the national legislations on the protection of personal data. Why this topic continues to be an elephant, I will show you based on 2 cases. One of the medical sphere, one completely out of another context. 2 cases where we kind of commonly thought that the data that was being presented could be perceived as anonymous. But very simple experiments showed that, in fact, they are not so anonymous. And I truly believe that that is one of the causes of the discussion being continued. The data sets that are available continue to grow, and the technical means that allow us to make links between these data sets, increasing the linkability of data, also continue to grow. The first experiment that I wanted to show you is one that dates already from 2019. It's an experiment where the MRIs or CT head scans that you can see at the top of the slide there were used in combination with facial recognition technology to re-establish who was participating in a medical study. The researchers were given the MRI or CT head scan and only that. There were no metadata, no medical data, no clinical data, not even an indication of where the MRI or head CT scan was made. Nothing. Only the MRI head CT. The researchers applied facial recognition technology to these MRIs, trying to make a 3D model of the head, and then combined the 3D model that they had created with data that were publicly available. Images, Google search. And they achieved a high success rate. For over 90% of the cases, the participant of the research was within the top 5 that they had selected. So they could not always establish one-to-one an identity, but it was within the top 5. A few years ago, had we imagined that based on a simple MRI or head CT scan without metadata, patients could be re-identified, I think many of us would not have answered yes to that question. Yet it is possible. A second case that should make us reflect on this concept is one that comes from law enforcement. What happened in this case, and it's very lawful to re-identify in this case, of course, I'm not discussing that. What happened in this case was that lady that you see at the bottom of the picture, she's going to throw a burning bomb at a police car. Funny enough, there were no videos, no CCTV images from this incident, just this picture. Obviously, the police wanted to re-identify that person, and lawfully. Do you know what they used to re-identify her? They used her T-shirt. She didn't buy the t-shirt from H&M or Zara. She happened to buy the t-shirt from Etsy. And Etsy is a platform where you have personalized items. And on Etsy, she bought the t-shirt and she left a review to the designer of the t-shirt about how she liked the t-shirt. These two elements were sufficient for law enforcement authorities to re-identify that lady. So anonymity, I'm not so sure. The question now, of course, is, and now I come to the frustration of Professor van der Aa. The question now, of course, is, what would we have done if this is not plant-based, but human-based tissue? Should we call this anonymous or not? Typically, these images are also available in a medical record, obviously identifiable. But typically, these images are not available online. So I cannot do a Google image search to find the exact same image and to find a trace to our patient. I think the two key questions that we have to solve in order to be able to reply on what is anonymous and what is not anonymous are those two. The first one is that we have to keep in mind that there is a multitude of very simple experiments that show the ease of identification in all kinds of data sets. And how can we mathematically prove that in a certain data set data are not re-identifiable? We have some data protection authorities, such as the ones in the UK, who are proposing methods to do so. They call it a motivated intruder test. These tests are highly complicated. They have to be done at the beginning of your research and have to be repeated depending on the technological development that we see within, for example, a sector. I'm not so sure if that is the answer to the issues that our healthcare scientists are running into. The second key question is the question whether or not in such an assessment I should take into account information that is available only after performing illegal actions. If I want to combine information from a medical record to re-identify a patient, of course I have to break into that medical record. And breaking into a medical record is an offense. I do not have the answer to this question. I am very much looking forward to decisions by the European Court of Justice, and we have several that are in the pipeline. But contrary to what I have seen in some publications, I think the decision is not there yet. We have seen indications that they will not go towards an absolute interpretation of anonymity. They will go more towards the interpretation such as we see in the UK now. But these decisions have been appealed, so we are not yet sure. That's it on anonymity. I'm going to leave it at that for anonymity. What I should say is that it's not because data are not considered anonymous, but are considered, for example, pseudonymous, that we cannot use them. Let's get rid of that misconception that we cannot use pseudonymized data, even in sensitive contexts, such as the medical context. GDPR does not prohibit the use of pseudonymized sensitive data, for example, for research. Yes, you have to take into account several principles, and yes, GDPR will try to prevent cowboy behavior, but no, there is no prohibition to use these data. And you can make use of techniques such as federated learning. Federated learning has many advantages. The security and confidentiality of individual level data is that's at least the attempt that goes up. The risk for misuse of individual level data goes down because you keep the data in your database locally. And legally, it may be a little bit less complicated because there is no data transfer of individual data. There is a transfer of aggregated data, but there is no transfer of individual data. So that may make it a little bit more easier in your agreements. But does federated learning solve all the GDPR questions? No. There is still data being processed for a secondary purpose, and so GDPR is applicable. Patients, for example, will have to be informed about that secondary purpose. Transparency obligations are there. All the GDPR principles that apply to the secondary processing also apply in the context of federated learning. Data subjects do have rights, such as the right to information, and the roles and responsibilities of the parties that are involved have to be agreed upon and have to be translated into contracts. We are facing this situation where you have data subjects, our patients, where you have data custodians, typically the hospitals, and where you have data users asking questions to the data custodians. On the question how much input there should be, or how much autonomy there should be from the data subjects, the debate is ongoing. The debate is ongoing in the context of the European health data spaces, and we see very diverse views. Some say that data subjects should always have a say in the secondary use of their data through the ability to consent. Some say that data subjects should not have any voice in the secondary use of data because the interest of society prevails, data as a common good. And some would like to go for a way in between, whereby data subjects are not necessarily asked for their informed consent for the secondary use, but are given the opportunity to opt out from the secondary use. Let's see how it goes. I cannot predict. I cannot predict in particular because we seem to have very different views across the member states in Europe. I did understand from the Health Data Agency that Belgium would like to accommodate the reuse of data as much as possible by considering it a common good in situations where it concerns research, innovation, education, for example. Could these data subjects claim that they are the owner of their health data? No. True, no patients, no data. But also true, no doctor, no lab technician, no nurse, no added knowledge or inferred interpretations. Legally, the concept of ownership means that there would be the right to decide solely about who can have, who can hold, who can destroy the data. And we do not have such a sole decision-making power for one party, not for the patient, not for the data custodian, not for the data user. In Europe, in Belgium, in Europe, we have legal frameworks that recognize certain rights and obligations, but we have no legal framework that recognizes ownership over data. Not even for the non-personal, by the way. The message that I would like to finish with is the following. And this is what we are going to launch also at the university hospitals in Leuven. At least I'm not anymore, but I'm proud to have contributed to that. Medical data does save lives. I don't think I have to convince you of that. It does save lives, and we should not be afraid to tell that to our patients. It saves lives, in particular your lives and not necessarily my life when it concerns my data. And this is a misconception that we have in society today and that we have to get rid of as well. If I get sick tomorrow, I will benefit from your data. That's just the way it is in healthcare. That's also why it is not necessarily individual autonomy that should prevail at all times. We can take into account public interest when it comes to, for example, research, where we are trying to achieve better healthcare for a lot of people. To finish off with a legal footnote, it is true that the GDPR always requires a legal basis for data to be processed lawfully, but it is not true that it always requires informed consent. Informed consent can be a perfectly good instrument in some situations, but not in all. Informed consent can be used if we can present very specific cases to patients, very specific questions. Would you agree? Would you not agree? And typically more not so much in retrospective situations where you have to recontact your patients. So GDPR does not require informed consent, does require a legal basis. For research, this is easily solvable given the emphasis that the European legislator has put on the importance of research. The only problem that we sometimes face is when we go international, because there is Article 9 in the GDPR that allows member states to add more restrictions into their national laws. And this is what we do see in some of the European member states, for example, with regard to genetic data or health data in general. And with that, I would like to wrap up. Thank you.
Okay, then we go to the next topic, which will be presented by Magali Fees. Magali holds various degrees in all aspects of intellectual property, information technology, data protection, and health law. And she will explain us a bit further her point of view on this interesting topic. So please, Magali.
Good afternoon. I'm going to follow on Griet's presentation, and I think it's a sort of addendum to what Griet has been saying on, I think, definitely anonymization and pseudonymization apart. And I want to stress, because I think it's also something Griet already touched upon, is the fact that I see from my practice that a lot of people are actually trying to go into that bucket of anonymization in order to really avoid GDPR. And actually that is what I believe, not necessary. You can say, okay, you're a GDPR lawyer, data protection lawyer, of course, that's your business. But it is true that actually when you look at, and I'll come back to pseudonymization because I'm a true fan of pseudonymization, of the concept of pseudonymization, and I will also explain you that the GDPR has a very specific definition of it, and it really, the threshold for pseudonymization with the introduction of the GDPR meant really something different than pre-GDPR. But it's very important to understand that the GDPR has three fundamental pillars. There is a legal pillar, there's an ethical pillar, but there's also a technical pillar. And from the moment you're trying to discuss or solve issues like pseudonymization and anonymization, only with all due respect for us, the legal professionals, and also I hope we have also an ethical point of view that we take into consideration, if you only do it with us, you're lost. And you will get in discussions from a very legal perspective, but then also in practice, you will come to the examples that Griet has been given and that re-identification is possible. So you really need to take into consideration also that technical part. And one thing that I really want to say is, if with the GDPR, please forget that you will not find the holy grail or one solution that fits all. And sometimes I hear people talking about federated learning, and we're in a project about federated learning with also EMEC, and it was presented as it's privacy preserving. It is very privacy preserving, federated learning. But it's not that you can say, oh, when we do federated learning, GDPR, check that box. No, you still, and I will show you that you still need to do pseudonymization, probably, even in a federated learning context. So indeed, there is a part from the perspective, the legal perspective, data subject request, the more ethical perspective, the principles of GDPR, but there is also the fundamental obligation to translate that in technical safeguards and organizational safeguards. And that is something you have to embrace, because it also means that you're protecting data security, that you're protecting, I'm also an IP lawyer, so that you're protecting your trade secrets, the confidentiality, and that you're gaining the trust of your patients by making that sure that the data is processed in a very secure way. I also wanted to say one thing about data ownership, and I know, and I'll give it with regard also to consent and as a legal basis. I wanted to say that I'm not the biggest fan of consent, but I don't want to stop my sentence there. I'm a big fan of consent. The problem is that consent today under the GDPR is often misused or misapplied, and it's not a true GDPR consent. Foremost, what I also see, and I work also with patient organization, that we see that if you ask patients for their autonomy, that it's not so much the fact whether they want to give consent or not that is bothering them today. If you talk about their data, where their data is, that if you ask patients, and even all of us in this room, you probably ever somewhere a patient, and you ask, do you have any idea of the secondary use of your data? We're oblivious. I have to say, I'm patient in 2 hospitals near Ghent, or in the city of Ghent, and I have to say I have no clue. Apart from the clinical trial I have been participating in, where I have given a consent, I have never seen any transparency about the secondary uses. And I think that we therefore today are trying to solve a transparency problem with a legal ground, and that we are applying consent as a part of, if we give consent, then the patients are informed, so then people will know where their data is. I don't think, first of all, that is true. If you think about cookies, you're a room with very smart people, so you will probably know that if they're the cookies, that you have the real-time bidding platforms, that actually today, as we speak, in nanoseconds, our profiles are being traded just for that little space on our Instagram or our Facebooks or even our LinkedIn's and everywhere. The problem is, or I want to really test it and go to the Grote Markt here in Leuven and see how many people who accept every day tons and tons of cookie banners, giving their consent for those cookies, whether they understand how real-time bidding platforms work. I think that the answer will be very poorly, that people will say, no, I just accept cookies, I have no idea how real-time bidding platforms work. But they give their consent, no? They should know, because it's informed consent under the GDPR, and they are still clueless. So you see, be careful that we're not trying to work out a transparency problem by actually creating it a problem from a legal ground. Also because I think the GDPR gives you already legal grounds on, for example, definitely scientific research. It even says then when the research is compatible with your primary purpose, the search for a legal ground is even not there. It is not there. It might be even that if it's not well compatible, or the compatibility can be seen, and there are a number of criteria in Article 6 that, for example, says if you pseudonymize the data, your chances in order to have a compatibility test that checks out is actually higher than without pseudonymization. By the way, pseudonymization is mentioned 15 times in the legal body of the GDPR. Next to encryption, that's the only technical criteria or concept that is being used. So it's very, very important, and it's put there within a reason, and it's put with a reason, or anonymization does not appear in the GDPR, and Anna Bukta from the EDPS has explained that that was done really with purpose, that they did not want to include anonymization in the GDPR. Now, if you don't have the compatibility test, then indeed you must look for a legal ground. But there are legal grounds, as Griet already mentioned, and we will see that next to consent, for example, there is legitimate interest. And I also want to point out, because I'm a little afraid with the thing of having your patient asking for, or asking your patient for consent for secondary use, and also knowing that I'm a big fan of AI and research, the fact is, are we not maybe creating a bias? Is every population, or are there maybe not parts of people who are going to say, I want to give consent because, like we have with cookies, some people accept all and they have no clue, but they're not interested in knowing what's behind. You have people who say reject all, and you have people say, oh, we want to make a dedicated choice. And maybe in that choice there could be a bias, because maybe those people come from a different background and could therefore have also maybe different health conditions. So we should be very careful by applying consent on the data quality and the data that we have in order to do research with. Also, indeed, I do not believe that at every time the right of an individual should go before the right of the society for scientific research. And I'm very afraid that if we ask every time for consent, like we do with cookies, people at a certain point will say, no, we do not give our consent anymore. And also that maybe by giving consent, you shift the liability, or there could be a potential of shifting the liability towards the patient and saying, well, you consented to it, right? So you can't complain afterwards. You had the right, you had the choice, but you took that one choice. So I think we should be very careful by applying consent. Definitely GDPR consent, that must be informed, that must be explicit, and that there should be a free option to give consent, which also in a medical context, from an ethical perspective, if you have a kid or a partner or yourself and you'll be very ill and they ask, I give you consent? And you say, oh, but there is no really, I hear sometimes people saying, yeah, but there's no value attached to it. But don't you think that people might not think and say, well, we're going to give our data and we want to give consent, because if we do so, then maybe the doctor will favor us. And I'm not saying that doctors will per se do that, but it could be a reason why people are consenting and not so much because they're really completely informed and they really wanted to give their consent as such. So is that freely consent really something that is out there? On the other hand, we could ask for an ethical consent that's much more, we could lay in more health law and say, for example, if patients come to a hospital and they register, that you say, can we give your data or use your data for secondary use, and that they can agree or not. But still, I would be very careful in always applying even such an ethical health law consent as such. Now, up to secondary use of data, because there is, I think it's already also a data governance model prepared by the university hospitals, but we were asked, I think a couple of years before, in order to present a data governance model for a couple of hospitals for secondary use. And we came also up with the fact that indeed, sometimes you really, first of all, we see that there is a problem of labeling, not so much scientific labeling, but with regard to also which data, how the data can be used. I have seen projects where data was under contractual obligation not to be further used. Yeah, then even GDPR can have all its rules. If you have a contract between two parties and it says it can only be used for this specific research and it cannot be further used, yeah, then the situation stops there. So I think very important that we know that you structure and label data, and that also data, that's data lakes or data warehouses. I know a number of hospitals are really into the creation of data lakes and data warehouses. Now, and then I think also that's very good, a data lake, a data warehouse, you can protect with encryption. You can do some data minimization on there, but we're definitely not a fan of already pseudonymizing, or as some people call it, anonymizing, but I will come back to that, the data before you put it in the data lake. Because the thing is, if you all think about your research, and I would ask you, yeah, pseudonymize or anonymize the data and put it in a data lake, you will do it from your use case. And that is a problem. If your use case is what is the correlation between breast cancer, women, and smoking, then you don't need so much parameters in order to have such a study. If you are training an algorithm, you probably need much more data. So be careful in minimizing data already before the specific use case. And when you come then to a use case, I'm going to go a little bit quicker because I really want to talk about pseudonymization. It is very important to have that step of pseudonymization. Okay, you can also call it, or indeed, Article 89 of the GDPR states you have to anonymize the data. Problem with that in a hospital is if you anonymize your data, that also means that you have to actually not be able to re-identify the data anymore. Meaning that if you have the health records of the patient, you should actually throw them away. Probably not such a good case, given that you have a primary use. So I already think in hospitals, with all due respect, anonymization is something yet, it is a word that I would not that often use. Then there is pseudonymization, and there I will explain how it is a new standard under the GDPR that is a really high standard, and that the more complex your data is, the more you need technology in order to attain pseudonymization under the GDPR. Because with all due respect, Griet, you mentioned the de-identification principles from HIPAA. I think in a number of complex data sets, it could well be that the result is even not pseudonymized data. So I think, so that's very, it's a very high standard, and we will come to that. In the fact, and also the thing that pseudonymization has a number of benefits. And it is not the same as anonymization, but it is also not failed anonymization. And what is it really about? It's the fact that you separate the identity from the information value. So in such a way that you create a data set, use case specific, because that's very important, because indeed the use case of a correlation and a statistic study on smoking, breast cancer, and being a woman is different from the data you need indeed to train an algorithm as such. But you have to create a data set, which is this information value, that taking this data set on its own, it should not be re-identifiable. So meaning you should not be able to jump over the wall to go back to Alex Smith without the additional information. So meaning also in Griet's examples, the fact that they were able to identify some of those data actually means that they were able to jump over the wall, so that that data even would not be considered under the GDPR as pseudonymized data, and this does not comply pseudonymization. So the only way in order to go from the information value, which is really the data value that you need, that's why you need to do it use case specific, is going through the additional information, which is your toolbox, which is actually the different privacy enhancement techniques that you have to apply. And as already said, and I think Griet's examples really demonstrate this, the more complex the data is, the more data you need, the more complex your privacy enhancement techniques will be. And you will not reach pseudonymization by applying only one privacy enhancement technique or two privacy enhancement techniques. And if we think about k-anonymity, we can all say with small cell, k-anonymity, or when we talk about genetic data, probably k-anonymity and everything will not cut it. It will need innovative research and software solutions in order to do that. There are some, but be careful, and I know that does not make everything easy, but we have clients, or there are software solutions that pseudonymize data, but some do it on medical images, others do it on really tables, but I have not seen one who can do both. So that's very important to understand that indeed it's not that easy. That's the same with synthetic data. But you really, and this is then the definition of pseudonymization in the GDPR. And it really has two parts. It has a legal part that says, okay, pseudonymization is personal data, that the personal data can no longer be attributed to the individual as such, without, you only can do that with the use of that additional information, so your toolbox. Remember, you can't jump over the wall. The only way to re-identify the data is in a controlled way, is by that additional information. So that means that it must be for the data set in its whole. Because I sometimes hear that people say, oh, we pseudonymized or we used a pseudonym for every line in the data set. So for example, your national security number got a pseudonym. And then that other column also got a pseudonym. That's one privacy enhancement technique. Probably that will not cut it in a complex data set. You will need to have other privacy enhancement techniques in order to make sure that the outcome of the entire data set is indeed that data set that without that additional information, you cannot re-identify the person. Meaning also that it's not only on direct identifiers, like a name, a social security number, or whatever, but also on indirect identifiers. And I think the examples of Griet, once again, really show that by using indirect identifiers, re-identification was possible. And it has also, and I think there sometimes people stop with the definition, but it also has a very technical part, very logical, because it's a third pillar and the equally important pillar as the other two of the GDPR. That's it. The additional information has to be kept separately and is subject to technical and organizational measures, which means that, remember, I don't know if I can go back with this, but I'll try. No, this is something else, but okay, no problem. Remember, the additional information was also walled. It's an image to really show that it's protected by technical and organizational measures. So meaning that not everybody should be able to have access to that toolbox. This is a slide to show you all the articles where GDPR is really mentioned in the GDPR. And if we see, it is, if you use pseudonymization, you are doing data protection by design. And data protection by design is the technical translation of the ethical and legal principles of the GDPR. It really enables data sharing, it enables secondary use, and it enables also research as such. And it's a support for legitimate interest, because indeed, given the fact that you apply pseudonymization, it really shows that you can comply with the necessity test and the balancing of interest test. Because the necessity test under legitimate interest states that the way you do this, if you apply legitimate interest, that the way you do it should be the most privacy preserving, and that there should not be another way that is more privacy preserving than your way of doing it. Well, given that pseudonymization is specifically mentioned as data protection by design, as a good example of data protection by design, you can really comply. We also have, we're very proud of that. One of our clients, we attained a decision of the Belgian Data Protection Authority that using pseudonymization really made sure that footfall in an airport, that the footfall AI was actually seen as data protection by design, and thus it was not legitimate interest because it was for governments, but that it was under, that we could comply with the necessity test and the balancing of interest test. Why is that also very important? And this is the good thing about pseudonymization. Pseudonymization makes sure, if you read the GDPR, that a number of the rights of the data subject, by applying pseudonymization, are already complied with. And thus, that the burden on the person that works with pseudonymized data and thus have to comply with data subject rights is much less, and that's a very important one. And that's also the reason, in one of the court cases before the European Court of Justice, we filed an intervention for one of our clients stating that pseudonymization indeed must be seen as an objective result, meaning that it then also, when the data is transferred to another party, it should still be pseudonymized data. Why? Indeed, as Griet mentioned, because it's very important we still comply with that ethical and legal and some of the legal principles of the GDPR, because otherwise the data is out there, and with also technology evolving and more data that is there, the risk for re-identification will always then be there. And if we still construe it as pseudonymized data, but knowing that the obligations are less because you already comply with data protection by design, it really gives you the benefits of the GDPR without the disadvantages of the GDPR. Thank you.